Assalamualaikum, my name is Muhammad Iman bin Fadhlan. I'm from DIA 3A. My ID number is IDA2010013.
Hello and Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Hafiz bin Zulmajdi from the IA3A. My ID number is IDA 2010002. Discharge of contract. Discharge of contract happens when the parties of the contracts release from any obligations arises under the contract. Or we can simply say that the parties are no longer obliged to do as they have agreed under the contract. There are four ways to discharge the contract, which are discharge by performance, discharge by agreement, discharge by breach, and discharge by frustration. So the first one is discharge by performance. Discharge by performance is the most common way to discharge a contract. The contract will be discharged when the parties of the contract has performed as what they have agreed under the contract. For example, Khairul offers to sell his wallet to Amin for RM50. So in this case, the contract will be discharged if Khairul give his wallet to Amin and Amin give RM50 to Khairul. In section 40 Contract Act 1950, it stated that the contract must be performed in its entirely unless otherwise agreed by the parties. There are 7 elements under discharge by performance, which are time of performance, place of performance, reciprocal promises, contingent contract, tender of performance, personal performance, and joint agreements. So for the first element in discharge by performance, which is time of performance, under section 49 Contract Act 1950, it stated that the promisee must apply for contract to be performed at the proper place and proper business hours if the promiser had not undertaken to perform it without promise's application. Under section 15 Contract Act 1950, any delay in the performance would entitle the innocent party either to terminate or continue with the contract. The example case for this section is the case between Sim Chio Huat and Wong Tet Fui, where it was held that the respondent had waived his right to resign the contract when he ordered extra work to be done by the appellant after the original delivery date had passed. The next element is the place of performance. Under section 50 Contract Act 1950, it stated that where the place for performance had not been determined by a contract, then it will be the duty of the promiser to ask the promisee where he would want the contract to be performed if the performance is to be effected without the promisee's application. So this section explained that if there are no fixed place to perform the contract, then it would be the promiser's responsible to ask the promisee where he would want to perform the contract. For the reciprocal promises, under section 52 Contract Act 1950, the promise and its consideration is to be performed simultaneously at a future date. No promiser need to perform his promise unless the promisee is ready and willing to perform his reciprocal promise. So it explained that the promiser not bound to perform unless reciprocal promisee ready and willing to perform. The example case for this section is the case between Central Malaysia Development Ltd and Chin Pak Chin, where it was held by the court that the plaintiff was entitled to repudiate the contract and recover the deposit since the defendant had failed to deliver the vacant possession of the land as promised. Under section 54 Contract Act 1950, it stated that where the one party prevents the other from performing his promise under a contract, the contract is voidable at option of the party so prevented. for the contingent contract, it was defined under Section 33 Contract Act 1950, where the contract to do or not to do something depends on some event collateral to the contract does or does not happen. Under Section 33 Contract Act 1950, contingent contract cannot be enforced until the happening of the event stipulated in the contract if the contract is contingent upon the happening of a future. The example of the case for this section is the case between Aberfoyle Plantation Berhad and Kau Pian Cheng, where the court held that the purchase of plantation was void because of vendor failed to obtain from the government the renewal of leases on 7 of the lands. For the tender of performance, it was stated under Section 38(1) Contract Act 1950, the parties must perform or offer to perform the respective obligation in order to discharge their contractual obligations. Furthermore, under Section 39(2) Contract Act 1950, tender of performance must fulfill these conditions, which are unconditional, met at the proper time and place, met under circumstance that the other party may have reasonable opportunity to ascertain the promisor is able and willing to perform the obligations. And lastly, the promise must have reasonable opportunity to see the things offered to be delivered. The sixth element in discharge by performance is personal performance. Under Section 41 Contract Act 1950, it was stated that whether or not the parties to a contract are required to personally perform their respective obligations depended on their intentions at the time the contract was made. The example case for this section is the case between Lechumi Amal and Nam Fong Housing Sendirian Berhad. It was held by the court that the contract had to be performed by the appellant personally. While under Section 42 Contract Act 1950, once the promisee accepted performance by a third party, he cannot afterwards seek to enforce it on the promisor. For example, in the case between Haji Nik Ishaq bin Haji Nik Daud and Haji Nik Zainab binti Nik Jaafar, the court held that the appellant cannot claim the balance of the purchase price of a piece of land from the respondent, since the appellant agreed to accept payment of the balance by the respondent's sign. The last elements in discharge by performance is joint agreements. Joint agreements is when two or more persons have made a promise to a promisee under a contract. Under Section 44(1) Contract Act 1950, where the promisors are jointly liable, the promisee may compel one or more of the joint promisors to perform the whole of the promise. While under Section 44(2) Contract Act 1950, if only one of the promisors was sued and he has made full payment to the promise, the promisor concerned can claim from the other promisors for their shares of liability. Now we are moving to the discharge by agreement. Discharge by agreement is when the parties agree under free consent to discharge obligation from the former contract. Discharge by agreement can be made during or after the contract has been made. For example, Khairul entered into a contract with Amin. In the contract, both of them agreed that the contract will be discharged if the profit of a year is lower than RM100,000. So, if the profit is lower than RM100,000, then the contract will be discharged by agreement. Under Section 63 Contract Act 1950, it explains about the novation, which is substitution of the existing contract. Parties can agree either to substitute existing contract with a new one, or to resign the original contract, or to alter the original contract. While under Section 64 Contract Act 1950, it's explained about the application of the dispensation or remission of performance. There are 4 situational examples. The first one is the payment of a lesser sum to satisfy the whole debt. Next one is the payment of a lesser sum by third party to satisfy the larger debt. The third one is the payment in satisfaction of an unascertained sum. And the last one is the arrangement for the settlement of debts between a debtor and creditors.
Move on to the discharge by breach definition. Under Section 40, when one party to the contract is in breach of contract, the other party to the contract has right to rescind the contract and claim damages from the breach. Example case: Cho Yin Lo vs. Visuvalingam Pillai. In this case, court allow a contract to be rescinded when an employer fails to pay wages 1 in every 2 weeks as promised. A breach may be made expressly or immediately from one conduct. A contract can be put to the end if a party to the contract did not do what they have promised in the contract. Section 40 of the Contracts Act, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promise may put an end to the contract. Next, a breach may occur because of 2 things. First, refusal to perform. Refusal to perform is where one party informs the other by conduct or words that he does not want to go on with the contract. The former party is said to repudiate the contract. Second, disability to perform. If one of the party is disabled to perform, the contract is discharged. If the disability is because of something beyond the control of the parties, then it does not amount to breach of contract, but is discharged through frustration. A breach can either be an anticipatory breach or an actual breach. For anticipatory breach occurs when one party indicates before the time of the performance due either first, that he does not intend to perform, second, that he intends performance different from that set out in the contract. The innocent party can either be first repudiate their contractual obligation as soon as the other party indicates their refusal to perform. Second, wait for the performance day and hope that the other party perform their duties. Next is actual breach. Actual breach is actually occur when performance is due on or in the course of performance. It can be either failure to tender any form of performance or performance is inadequate. The effect of an actual breach: the innocent party terminates the contract. He must restore or return any benefits received from other party in Section 65 Contract Act 1950. Further, if the innocent party has provided service or supplied goods, he can recover reasonable sum for it. The party who is not in breach of contract has 2 options. First, continue with the contract and claim damages, or repudiate the contract. These are example cases in actual breach. First, Smith Construction Company Limited versus Pit Kirivata. The case is actually about the refusal to issue an architect certificate as agreed under a contract amounted to a breach of contract because it prevented the contractor from proceeding with the construction of the building. Since the time is important in the contract, the party not in default has a choice, either repudiating the contract or treating it as a substituting. Next case is between Bon Hon Jomin Limited versus Chen and Yap Limited. The case is about the applicant has refused to make fortnightly payments for the work that has already been done by the respondent. The applicant also ordered the respondent to stop work. The respondent can treat the contract as being repudiated and could sue the applicant for the work that has been done. In Section 76 of the Contracts Act 1950, a person who rightly rescinds a contract is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract. Move on to discharge by frustration. Discharge by frustration is when a contract is terminated if the things that the parties agree to do is impossible to perform. It can be at the time when the contract was made or when the contract has been made. The obligation becomes impossible to perform. Two types of impossibility in Section 57 of the Contract Act 1950. First, in Section 57(1) Contract Act 1950, contract the performance of which is impossible at the time it was made an agreement to do an impossible act. Such contracts are void. Second, in Section 57(2) Contract Act 1950, a contract the performance of which had become impossible or unlawful after it was made due to some event the promisor could not prevent. The contract is said to have been frustrated and become void. In order for a contract to be frustrated, the following qualifications must be satisfied. First, the event that caused the frustration must not be self-induced. In example, not caused by the parties themselves. It must have been something beyond their control and not forcible by them. Section 57(2) of the Contract Act, the supervening event must be something that the promisor could not prevent. Second, the performance of the contract must have been impossible and not merely more difficult or more expensive. Also, the event that occurred has caused by fundamental or radical change in the circumstances so as to make the performance of the contract something radically different from the original undertaken. Lastly, the frustrating event has substantially prevented the performance of the contract as a whole. These are example cases in actual breach. First, Smith Construction Company Limited versus Pit Kirivata. The case is actually about the refusal to issue an architect certificate as agreed under a contract amounted to a breach of contract because it prevented the contractor from proceeding with the construction of the building. Since the time is important in the contract, the party not in default has a choice, either repudiating the contract or treating it as a substituting. Next case is between Borhon Jomin Limited versus Chen and Yap Limited. The case is about the applicant has refused to make fortnightly payments for the work that has already been done by the respondent. The applicant also ordered the respondent to stop work. The respondent can treat the contract as being repudiated and could sue the applicant for the work that has been done. In Section 76 of the Contracts Act 1950, a person who rightly rescinds a contract is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract. Next, circumstances in which a contract may be discharged by frustration. First, destruction of subject matter of contract. Second, supervening events defeat the whole purpose or object of the contract. Third, death or personal incapacity. Fourth, supervening illegality. And the last one, a declaration of war. Finally, effects of discharge by impossibility. When a contract becomes void for frustration, in Section 66 Contracts Act 1950 provides that any person who has received any advantage under it is bound to restore it or to compensate the person from whom the advantage was received. Second topic is remedies for a breach contract. Next is a remedies. Definition of remedies. Remedy is a general term which means a right that can be claimed by a party to a contract that experienced losses because of the other party to the contract was in breach. The right exists in many types: damages, specific performance, and injunction or quantum merit. For the first one is damages. Damages give to a person in a contract who does not receive the rights that he should from the contract. The aim of damages is to reward losses and damage because of the other party's breach. A person that claims damages must prove that the losses incurred because of the breach. The losses are commonly incurred and both parties expected the losses to incur if the contract is breached. Example case in Hadley vs. Vassender. In this case, plaintiff contracted with defendant to bring a machine from plaintiff's factory to a machine maker as a model. Defendant was late. As a result, plaintiff's factory cannot operate. Plaintiff claimed damages for profit loss. Plaintiff's claims was rejected. The losses incurred because the other machine is not functioning. Besides, both parties do not expect the losses to incur. The aim of rewarding damages are to give relief to the innocent party for the losses incurred, not to punish the party who in breach. Damages of unspecified amount are divided into three. First, substantial. Substantial, a reward given is to put plaintiff in a place that he should if defendant perform the contractual obligation. Second, nominal. Nominal, a small reward to plaintiff after he shows that there is a breach of contract, even though there is no real losses incurred. Lastly, exemplary. Exemplary, a reward given is far higher than the losses incurred. Lastly, injunction or quaternary. Injunction is actually discretionary given by court under Section 50, Specific Relief Act. An injunction may be of mandatory or interlocutory. The remedy of an interlocutory injunction is used by a party to maintain status quo of a subject matter in a pending suit. A mandatory injunction is a court order requiring something to be done. An injunction may also be in a form of restraining order, stopping something from being done. Why? MERUIT is a claim that can be made by plaintiff who has performed obligation under a contract and then choose to rescind the contract after defendant's breach. Court will order to value that is adequate. Thank you for watching this video. Hope you guys enjoy and get some inputs from this video. Don't forget to like and subscribe this channel. See you soon.